Hello friends, you are welcome in PVP video classes. I am Pankaj Kumar Tripathi going to present second video of the videos of Group G on the provisions of Civil Procedure Code 1908. Friends, in this lecture I will not only classify the special proceedings provided in the code, but I will thoroughly discuss some of the special proceedings like the proceeding under Order 14, 24, under Order 25 and proceedings under Section 90, 91, 93. Primarily, we should classify all the special proceedings provided in the code. I have classified all the special proceedings into 5 headings, into 5 clauses. First, Order 22, that is effect of death, insolvency or marriage of a party. What proceeding to be applied if a party dies, if a party becomes insolvent, is declared insolvent, when a party who is woman marriages. We will discuss the effect and proceeding to be applied on that kind of event in next video lecture. Second group is Order 23, to be read with Section 89. There, withdrawal of suit by plaintiff or compromise, either withdrawal of suit or compromise. Here withdrawal of suit or compromise. So to compromise you have to read Section 89 also. Okay. The third is Order 24. Order 24 is payment into court. Payment into court. Only this procedure is applied only in case of a suit for recovery of damages or of debt. Only then this provisions of this order is applied. The amount which has been claimed by the plaintiff may be paid by the defendant into the court. Okay? During litigation, before pronouncement of judgment, even. Order 25, security for cost. In some of the suits, when plaintiff is asked by the court to provide security for cost. So, under Order 24, it is defendant who makes payment into the court of the claim, of the amount claimed by plaintiff. The defendant makes the claim, the payment against the claim made by plaintiff. Under Order 25, it is the plaintiff who provides security, who gives security for cost to the court. But there is a difference between the two provisions. Defendant can make such payment into court at his own will, while court passes an order against the plaintiff to provide security for cost under Order 25. Okay? So these two orders must be understood comparatively. It would be then it would be interesting and easy for you. Section 90 to 93, I have classified the 4 sections into 2 groups. Section 90 to be read with Order 36. Special case, friendly suit. We will discuss this when we will discuss the provisions of special suits. Okay, so we will discuss in that group. Section 91 to 93 we will discuss here. Case related to public nuisance. Case related to public nuisance. Generally, public nuisance is offense but not a civil wrong. But under section 91 and 93, even civil suit might be instituted for damage caused in a public nuisance. Okay. So I would like, after classifying the special proceedings, I would like to describe the provisions of Order 24, provisions of Order 25, and provisions of section 91 and 93 only, but not of 92, because of provisions of 92 are not important for you. You have to memorize just a heading of section 92. Okay, in this lecture. So come on, the provisions of 24, payment into court. This is one of the smallest order. 24 is one of the smallest order of the code. ठीक है, ये छोटे आदेशों में से एक है, having 4 rules only. Okay. Under clause 1, deposit by defendant of amount in satisfaction of claim. The defendant in any suit, but not in any suit. Read the barrack. Read rule 1 of Order 24 carefully. The defendant in any suit to recover a debt or damages. So it means this order is applied only in a suit which is for recovery of damages or for recovery of debt. This provision is applied only in a suit for recovery of damages or for recovery of debt. Okay? The scope of this order is very limited. You have to underline it. The defendant in any suit to recover a debt or damages. What the defendant may do? May, at any stage of the suit, it also to be underlined, deposit in court such sum of money as he considers a satisfaction in full of the claim. What he thinks that what amount to be paid to the court, and it would be full payment, full satisfaction for the claim of plaintiff against him. Then he may pay the amount in court at any stage of the case, at any stage of the suit, in a suit which is either for recovery of damages or for recovery of debt. Actually, just as under Order 23, a plaintiff may withdraw his claim at any time before pronouncement of judgment. In the contrary hand, under Order 24, defendant can pay the claimed amount by plaintiff at any time. But here, defendant cannot be ordered to pay the amount. No, unless the case is decided and a decree is passed, how can defendant be ordered by court to pay the claimant by plaintiff? No. But it is open for the defendant to make the payment of the amount which is claimed by, which has been claimed by plaintiff against the defendant in the suit which is either for recovery of damages or for recovery of debt. Okay? If such payment is made, first of all I have to write rule 2, notice of deposit. Notice of the deposit shall be given through the court by the defendant to the plaintiff. Defendant may make such payment into the court, and then he shall have to make a notice to the plaintiff through the court, not directly, through the court, about such payment to the plaintiff. Okay? and the amount of the deposit shall be paid to the plaintiff on his application. And after receiving the notice, if plaintiff makes an application for receiving the amount, then the amount shall be deposited to the plaintiff. But there might be an exception, because in bracket it has been provided here in rule 2 of article 24 that unless the court otherwise directs. It means court may otherwise direct. Why court will have been empowered to make otherwise direction? Because if it is appear before court that the payment is made by defendant not with his free consent, because of being in undue influence, or because of being in under pressure of undue influence or misrepresentation, or because he is not able to understand his position, or where the case is a case under order 32 by next guardian, by a lawful guardian, by a guardian for suit, and court is satisfied that he is playing the role against the actual defendant. So there might be situations that even the payment of money is made by the defendant to be given to the plaintiff, and generally the amount shall be given to the defendant or to the plaintiff when an application is made by the plaintiff. But court has exceptional power to make otherwise directions. It means generally the amount what is paid by defendant for in the court to be paid to the plaintiff shall be given to the plaintiff when plaintiff makes an application for receiving of that amount. But exceptionally court may make otherwise directions. Okay, it has been provided in rule 2 of article 24. When an amount is paid by defendant, just from the date of paying the amount, no interest can be claimed by the plaintiff on the amount which has been paid by the defendant into the court. It means when the amount is paid by the defendant into the court, from that day no interest will be lie on that amount in favor of plaintiff. Okay. Rule 4. Procedure where plaintiff accepts deposit at satisfaction in part. Though defendant has made the amount, has made the payment, having a view that he is making full payment, but plaintiff accepts the amount as partial payment of his claim. Then what would be? It has been provided in Rule 4. Where the plaintiff accepts such amount as satisfaction in part only of his claim, he may prosecute his suit for the balance, obviously. And if the court decides that the deposit by the defendant was a full satisfaction of the plaintiff's claim, the plaintiff shall pay the costs of the suit incurred after the deposit and the costs incurred previous thereto, so far as they were caused by excess in the plaintiff's claim. Okay, this is not very important. Second, procedure where he accepts it as full satisfaction, even it has been provided in sub rule 2 of rule 4 of article 24, where the plaintiff accepts such amount as satisfaction in full of his claim, he shall present to the court a statement to that effect, and such statement shall be filed, and the court shall pronounce judgment accordingly, and in directing by whom the cost of each party are to be paid, the court shall consider which of the parties is most to blame for the litigation. If plaintiff accepts the claim, the payment made by defendant in satisfaction of his claim fully, then the question that who will pay the cost of the litigation will be decided by the court. If defendant has paid the amount just after receiving a notice or summons from side of plaintiff, then it would be presumed that the litigation has been started by the plaintiff without any cause, because defendant was ready to pay the amount. So why he has paid the amount? In that scenario, cost will be imposed on plaintiff. Cost will be borne by the plaintiff himself. If defendant has made objections against the claim made by plaintiff, but even after making the objections through written statement against the claim made by plaintiff, he makes such payment, then it would be clear that there was due reason behind the litigation by the plaintiff, because defendant was not ready to pay the amount. He has paid the amount voluntarily, but at the time of litigation he was not ready to pay the amount. Then it is the defendant who has to pay the cost. Okay, so we have described the provisions of Order 25(4). Now come on Order 25, security for cost by plaintiff. Order 25 is not applied always in every suit. It is applied only where either plaintiff has no immovable property in India, or he is a non-resident of India. He couldn't be. It is apprehended that if he would lose the case, he couldn't be called for providing of security to the providing of the cost to the defendant. Then he might be ordered by court either on application made by defendant or suo motu by the court to provide security for cost. Okay, that if he would lose the case, then the cost might be recovered from the security easily. Okay, so the main motto of that, to make it safer to recovery of cost from side of plaintiff. Okay, Order 32 Rule 2A should be read with it. Order 32 Rule 2A must be read with it. Even cost may be demanded from next friend if a suit is instituted by next friend under Order 32. Okay, so what the proceeding will be? There are just two rules in Order 25. So it is one of the smallest orders. It consists of two rules only, but it is one of the important orders. Not very important, but important. At any stage of a suit, the court may, it means it is power of court, the court may either of its own motion, underline it, either of its own motion, or on the application of any defendant, order plaintiff. Court may make an order to plaintiff. Court may order plaintiff for reasons to be recorded. Okay, after recording the reasons of giving such order, what order? To give within the time fixed by it security for the payment of all costs incurred and likely to be incurred by any defendant. Okay, to pay security for cost. Okay, but it's up to making such order, passing such order against the plaintiff is subject to discussion of the court generally, but in exceptional situation it is mandatory for the court to make such an order. When such order shall be passed by the court, it has been provided in the proviso of Rule 1 of order, sub-rule 1 of Rule 1 of Order 25. That is, as provided that such order shall be made. Underline the phrase shall be made. Such an order such be made in all cases in which it appears to the court that a sole plaintiff is, or when there are more plaintiffs than one, that all the plaintiffs are residing out of India. If the plaintiff or plaintiffs are residing out of India, then such order shall be made. And that such plaintiff doesn't possess, or that no one of such plaintiffs possesses any sufficient immovable property within India other than the property in suit. Such order shall be made by the court. Order to provide security for costs shall be made by the court if the plaintiff or plaintiffs are residing out of India and they have no immovable property other than the subject matter of suit in India. Then such order shall be given by the court to the plaintiff to provide security for cost incurred on defendant or defendants, or any of the defendant. Okay. Sub Rule 2 of Rule 1. Whoever leaves India under such circumstances as to afford reasonable probability that he will not be forthcoming whenever he may be called upon to pay costs shall be deemed to be residing out of India within the meaning of the proviso to Sub Rule 1. So, the proviso of Sub Rule 1 of Rule 1 of 25 is most important than the main provision, the general provision of Sub Rule 1 of Rule 1 of 25. Okay. Now, Rule 2. Effect of failure to furnish security. If plaintiff doesn't provide the security, then what would be the consequences? The consequences of failure to provide such security has been provided in Rule 2 of Order 25 as, in the event of such security not being furnished within the time fixed, the court shall, underline it, the court shall make an order dismissing the suit unless the plaintiff or plaintiffs are permitted to withdraw therefrom. It means then court will have to dismiss the suit. So it is another ground of dismissal of suit. Okay. Then what action can be taken by the plaintiff? What remedy is available to the plaintiff against the dismissal? It had been provided in Sub Rule 2 of Rule 2. When a suit is dismissed under this rule, the plaintiff may apply for an order to set the dismissal aside. They can make an application to the court who has dismissed the suit for setting aside the order of dismissal. Okay? And if it is proved to the satisfaction of the court that he was prevented by any sufficient cause from furnishing the security within the time allowed, the court shall set aside the dismissal upon such terms as to security, cost or otherwise, as things be, and shall appoint a date for proceeding with the suit. Okay? Sub Rule 3 of Rule 2 is also important, because the dismissal order shall not be set aside unless notice of such application has been served on the defendant. Okay? Unless a notice of the application has been served on the defendant, the dismissal order, the dismissal of the suit, which has been because of failure of plaintiff to furnish security, must be given to the defendant. If notice of an application for dismissal, for setting aside of dismissal order has not been given to the defendant, then court cannot take any action on the application made by the plaintiff for setting aside the dismissal. Okay? Another point to be noted: if the application made by the plaintiff under sub rule 2 of rule 2 is rejected by the court, then what relief would be available to the plaintiff? Okay, hear it, that an order is passed against plaintiff to furnish security for cost, but he doesn't do so, and non-compliance of the order of security consequences as to dismissal of the suit. Then plaintiff makes an application for setting aside the dismissal of suit under sub rule 2 of order 25, but the application of plaintiff is rejected by the court. Then what kind of relief would be available to the plaintiff? So you should read order 43 rule 1 subclause N. The plaintiff may go in appeal the rejection order of the application for setting aside the dismissal of suit under order 25 is an appealable order. If the decree would be appealable, there is a condition. If the decree would be passed and met, even it would not be appealable, then the order would not be appealable. The dismissal order, the rejection order, the order of rejection of the application which has been made by the plaintiff for setting aside the order of dismissal would be appealable, will be appealable under order 43 rule 1 subclause N. Okay? One thing more you have to mention here, that under order 41, order 41 is related to appeal. Under order 41, rule 10, appellate court may require appellant to furnish security for cost. Okay, so the same provision has been mentioned in for appeal order 41 rule 10. Okay, so we have made complete study on the provisions of security for cost under order 25 in a case of suit, under order 41 rule 10 in case of appeal. Okay, now come on provisions of section 91 and 93. Here much more not to be discussed, but these two sections are important for pre-examination and for interview only. I think that you know that generally public nuisance are not subject matter of civil litigation. Public nuisance is generally offense only. It is a criminal litigation, matter of criminal litigation only. But an action might be taken for public nuisance either under section 91 or section 93. Section 91, when a suit may be instituted for public nuisance, section 91 provides as that in the case of a public nuisance or other wrongful act affecting or likely to affect the public, a suit for declaration and injunction or for such other relief. For other relief means for damages, like in Bhopal gas कांड, Bhopal gas case. So, or for such other relief as may be appropriate in the circumstances of the case, may be instituted. May be instituted A, by the Advocate General of the state, or B, with the leave of the court by two or more persons, even though no special damage has been caused to such persons by reason of such public nuisance or other wrongful act. If special damage is caused to them, has been caused to them, then it would be private nuisance for them who had suffered the special damage. But no special damage has been caused, then it means there is no private nuisance, there is only public nuisance. But even then, two or more persons who have suffered damages from the public nuisance may institute a civil suit with pre-permission of court. Okay? And under section 93, the powers conferred by sections 91 and 92 on the Advocate General may, outside the presidency towns, be with the previous sanction of the state government, exercised also by the collector or by such officer as the state government may appoint in this behalf. It means under section 91, a suit may be instituted either by Advocate General or by two of the sufferer with pre-permission of court. If it is instituted by the Advocate General, then there is no need to take pre-permission of court. But if it is instituted by two of the sufferers, then permission of the court would be required. Or under section 93, by the state government or with his pre-permission, by collector or any other officer with pre-permission of state, with previous sanction of the state government. Okay? So there are possibility of institution of a suit against a public nuisance or public wrong. Under section 91, it would be instituted, it might be instituted by Advocate General or by two or more sufferers, more of the sufferers, but with pre-permission of court, or by collector or any other officer with previous sanction of the state government. Okay? So, I have described all the lectures, all the provisions which are to be described in this lecture. In next video, we will discuss the provisions of Order 22 separately and provisions of Order 23 in another video separately. Okay? So, enjoy the lecture. Okay? We will meet in next video lecture with Order 22. Okay? Bye.